Okay, a recent decision in the Bureau of Immigration Appeals, which is the Immigration Appeals Court, a decision was made on February 14th, which, yes, is Valentine's Day, that completely changes the game for people who have a history of entering the United States, multiple entries, and overstays in the United States. This decision, which was the matter of Duarte-Gonzalez, was decided that now changes how immigration will process requests or the eligibility for requests for green cards, adjustment of status. It also has an impact and it relates to the waiver process. So now the government says that no longer are people who have multiple entries going to be punished only outside the United States for those entries. So the 10-year bar is no longer going to apply only to people if they're outside the United States. This is massive news. So in the past, for someone to be eligible for a waiver, so that's a 601 or 601A waiver, they were required to fulfill their 3 or 10-year bar outside the United States before they are eligible to even request a waiver. Even if they requested the waiver, if they hadn't fulfilled that 3 or 10-year bar, they would not get an approved waiver and therefore would not be allowed to move forward with the green card process. So this decision changes all of that. So now people can start the clock, or the clock runs while they're inside the United States. So you leave the United States, you get a bar, you come back. The clock doesn't stop. It keeps running. So you can see that being able to run your time while in the United States is a major benefit, because so many people would have to basically leave their families for up to 10 years to be able to do the thing that immigration said in order to fix their papers, okay? So let me give you a quick example, okay? So in this example, we're going to be talking about Carlos. So Carlos entered the United States without authorization, or Carlos entered the United States with authorization but overstayed his visa. Then, after 1 year of being in the United States, Carlos left the United States to go back to Mexico. The moment he did that, the law automatically applies the 10-year bar. Anything over a year in the United States without authorization, leaving automatically triggers that bar, okay? So Carlos now leaves the country, technically has a 10-year bar. He returns, right, which technically would be unauthorized entry again. In the past, that was a deal breaker. No one could do anything if they had a multiple entry, especially after being in the United States for 1 year or more. So Carlos leaves, comes back. The 10-year bar technically is still there, but he's able to come back, be with his family, find work, whatever he did before, he's able to do in the United States, and the clock still runs. So at the end of 10 years, if he got a 10-year bar, if he had a 3-year bar, it's only 3 years, at the end of that bar, Carlos would then be able to petition for a waiver in order to correct the prior problems he had. So once he does that, he can then correct the situation and move forward with his green card process. In most cases, the green card process will happen within the United States. So Carlos leaves, comes back, spends time with his family, does whatever he does to live with his family, and is still able to move forward with his green card process. This is an absolute game changer, okay? So this will change the way everybody approaches leaving or re-entering the country, especially with people that have been here for many years. There's lots of people that have had these problems, and they're still in the United States, and they've been here for 20 years. Well, under the old way, all bets were off. There was nothing they could do to fix their process because they never left the country. They never stayed out there and let the bar run. Well, now you can do it in the United States. So many of these people, I mean, we're talking tens of thousands or more people now will be able to petition for the green card, a lot of times through U.S. citizen children over the age of 21. They can apply for a green card process now after being in the United States for more than the bar. So a 10-year bar, you're here for 15, 20 years, you already are good, and you can now apply for the green card process and go through the, if a waiver is required, you go through the waiver process in order to fix any other issues you have. But the key is you don't have to be out of the country in order to do it. Again, major news, again, in the decision that was on Valentine's Day by the Bureau of Immigration Appeals. This is massive. So we're telling clients, contact us. If you have a history where you have multiple entries, exits, and you had previously been told that you can't do anything, that was probably true, you can do something now. So you need to call us so we can help you figure out what path you need to take and how we move forward with this amazing change under immigration court, okay? There's a similar thing that Biden introduced, I don't remember when it was. It was within the last year, I think 2023 again, where he says that people, the 10-year bar would keep tracking no matter where they are. This is very similar, but this deals with the court. So this gives even more solidity or confidence in people when they do this process, because it's now the immigration court saying it's okay, and it's the Biden administration, aka USCIS, is saying that people can now benefit, they can move forward. They're not going to be punished if they don't leave the country for 10 years. Again, this is huge. Give us a call, subscribe, click on our links, email us, whatever you've got to do to get in touch with us so we can talk to you about this to see if you are eligible for moving forward with your process given this new change in the law.